Ladies and gentlemen, welcome back to the Indie Zone podcast. My name is Kathy. On the 18th of April 2025, amongst multiple other verbal rulings memorialized to writing in a very long order, Judge Stephen J. Hippler ruled that defendant's motion in limine number 9 regarding excluding Amazon click activity evidence at trial is denied. Therefore, this evidence will be permitted to be presented to the future jury in this matter. What does this order say? Beginning on page 7 of this order, it states that the defendant moves to exclude any evidence of defendant's Amazon purchase history or, quote, click activity on the grounds that it is, quote, out of context, incomplete, and unfairly prejudicial. This evidence will be presented by the state through Shane Cox and Michael Douglas, who will testify simply to what the documentary evidence states, all of which was provided to defendant in discovery. Footnote 7. Within this motion, defendant also seeks to exclude testimony by Shane Cox and Michael Douglas on the grounds that their expert disclosures were insufficient. That will be addressed in a separate order regarding the defendant's motion to exclude vague and undisclosed expert testimony. This order goes on to find that this evidence is, according to Judge Hippler, highly relevant. A K-bar sheath was found lying next to one of the victims. Defendant's DNA was found on that sheath. Records from an Amazon account registered to the defendant's name and email show that a purchase of a K-bar and sheath was made from the account approximately 8 months prior to the crimes. Click activity on the same account shows the customer also viewed pages associated with K-bar style items at that time and in the week following the purchase, viewed pages associated with the shipping progress of these items. The product was shipped to, quote, Brian Koberger, end of quote, at his family address in Pennsylvania. After the crimes, activity from the same account showed the user navigated pages related to the deletion of account activity, and a week later viewed pages associated with K-bar items. This evidence established a significant connection between defendant and K-bar items. In addition, there is no basis under IRE 403, that's a rule of evidence, ladies and gentlemen, to exclude the evidence, particularly given how probative it is. Defendant argues it is misleading, prejudicial because it paints an incomplete picture of the account activity. To this end, defendant provides the declaration of his expert, David Howe, the founder of a firm specializing in digital forensics and digital marketplace analytics. According to Mr. Howe, far more information must be reviewed in order to attribute specific activity to a specific person or otherwise render an opinion about, and we go on to page number 8, ladies and gentlemen, to continue, user behavior with forensic certainty, including Amazon advertising logs, recommended algorithms, cross-device history, retargeting behavior, account personalization, and device IDs. Final paragraph, it says here, defendant is free to challenge this evidence through cross-examination and examine through Mr. Howe why more information is needed to reach the conclusion that defendants made the purchases or, quote, click. However, it is not a basis for exclusion. There is nothing inherently unfairly prejudicial or misleading about the evidence itself. It will be up to the jury to consider the evidence and decide whether defendant was the, quote, clicker. Thus, the motion is denied. So we see here where Judge Hippler is finding that this evidence is relevant. In quotes, he's saying here it's highly relevant. It should be up to the jury to determine what weight, if any, they put to the believability of expert witnesses on either side in their role as the trier of fact. This will now conclude this episode of the Indie Zone podcast. Thanks for joining.